Good evening. Welcome to Kenya News Update today. I'm your host. Tonight, we're diving into a story that sits at the intersection of free speech, international law, and the increasingly complex relationship between citizens and the digital world. It's the case of a British doctor, stranded in India for over a month, barred from returning to his life and work in the UK over a single Facebook post. This is more than just a travel ban. It's a window into a global debate about online expression, state power, and the rights of individuals in the digital age. We'll examine the facts of the case, explore the legal mechanisms used, and connect it to a much broader conversation happening from Paris to Nairobi about who controls the narrative online. We'll also look at a parallel story from Ireland, where the state was ordered to pay significant compensation to asylum seekers left homeless, raising questions about state responsibility versus individual rights. This is a 12-minute deep dive. Let's begin. Our story starts with Dr. Sangram Patel, a UK citizen of Indian origin and a doctor working with Britain's National Health Service, the NHS. On January 19, 2025, he was at Mumbai's CH Chhatrapati Shivaji Maharaj International Airport, ready to board a flight back to London. But at the immigration counter, he was stopped. Authorities informed him he could not leave the country. The reason? A lookout circular had been issued against him. This is a notice, typically used for suspects in criminal cases, that instructs border officials to prevent a person from leaving India. The alleged crime? A social media post on Facebook. Specifically, a post that was critical of a top politician from India's governing Bharatiya Janata Party. The BJP. Dr. Patel has been stuck in India ever since, unable to return to his job and his life in the UK for more than 30 days. The police case against him was reportedly filed in the state of Maharashtra under sections of the Indian Penal Code, related to promoting enmity between groups and statements conducing to public mischief. The exact content of the post remains unclear from public reports, but the consequences are starkly clear: one post, 1 month, one life on hold. This case immediately raises profound legal and ethical questions. First, the proportionality of the state's response. Is barring international travel, effectively detaining someone within a country, a proportionate response to an allegedly offensive social media post? Legal experts we consulted point to a troubling trend. The use of lookout circulars, or LOCS, has expanded beyond their original intent of tracking serious criminals and tax evaders. In recent years, there have been documented cases of activists, journalists, and now, an overseas citizen, being subjected to LOCS for what are essentially speech-related offenses. Data from Indian legal rights groups suggests that between 2021 and 2024, the issuance of LOCS for non-violent, speech-related cases increased by an estimated 40%. This tool, designed for border security, is becoming an instrument of political and social control. For Dr. Patel, an LOC doesn't just mean he can't board a plane. It means he is effectively at the mercy of a slow-moving legal system in a country where he is a visitor, facing potential arrest and prolonged court proceedings over a comment made on a global platform. Now, let's zoom out from this individual case to the global context. The debate about regulating speech online, particularly for young people, is heating up. Just this week, at an AI Impact Summit, French President Emmanuel Macron made a direct appeal. He urged India, along with other nations, to join international efforts to ban social media access for children under a certain age. Macron's proposal, part of a broader push for global digital regulation, argues that platforms like Facebook, Instagram, and TikTok pose significant mental health and developmental risks to minors. He cited studies suggesting that excessive social media use is linked to a 30% higher incidence of anxiety and depression symptoms in teenagers. His call for a ban, or at least stringent age gating, is framed as a protective measure. But critics see it as part of a wider, more concerning pattern: governments seeking greater control over the digital public square. They argue that while protecting children is a legitimate goal, outright bans are blunt instruments that can pave the way for broader censorship. The question becomes, where does child protection end and the suppression of digital freedom begin? This brings us to a crucial tension at the heart of our story. On one side, you have the argument for state responsibility and protection. Proponents of stricter online regulation, including measures like India's IT rules and proposals like Macron's, argue that the digital Wild West has caused real harm. They point to cyberbullying, misinformation that incites violence, and the exploitation of children. The state, they say, has a duty to step in and create guardrails. In Dr. Patel's case, from the perspective of Indian authorities, they are enforcing laws designed to maintain public order and prevent the spread of content that could incite communal tension. They are using legal tools at their disposal to hold an individual accountable, regardless of his nationality. The principle is one of sovereignty and the application of domestic law to online activity that originates within or is accessible within their borders. On the other side is the argument for individual rights and freedom of expression. Critics counter that tools like lookout circulars are being weaponized to silence dissent and criticism. They see Dr. Patel's ordeal as a stark example of digital exile, where a person's online speech results in their physical confinement. This chilling effect, they argue, extends far beyond one doctor. It signals to the vast Indian diaspora and to citizens everywhere that returning home could be risky if your online activity has displeased the authorities. Furthermore, the case highlights the asymmetry of power. A government can deploy the full machinery of the state, police, courts, immigration, against an individual for a social media post. The individual, in contrast, has limited recourse, especially if they are not a resident. This imbalance is at the core of the debate about digital rights. Is the right to free speech, a cornerstone of many democracies, being eroded by the very laws meant to protect societies from the downsides of the internet? To further explore this theme of state responsibility versus individual rights, let's pivot to a related story from Europe. The Irish Times recently reported a ruling by the Irish High Court. The court found that the Irish state failed in its duty of care to two asylum seekers. Upon their arrival in Ireland, these individuals were left homeless by the system meant to accommodate them. The judge was unequivocal, stating the state's actions amounted to a failure to vindicate their constitutional rights. The court ordered the state to pay significant compensation, €9,500 to one asylum seeker and €6,000 to the other. This ruling is a powerful affirmation that the state has concrete, enforceable obligations to individuals within its jurisdiction, especially vulnerable ones. It establishes that when the state fails to meet a basic standard of care, providing shelter, there is a financial and legal consequence. Now, contrast this with Dr. Patel's situation. In Ireland, the state was penalized for not acting to protect individuals. In India, the state is acting against an individual for his speech. Both cases revolve around the limits of state power and its relationship to individual rights, but they point in seemingly opposite directions. One case says the state must do more to protect. The other case, critics say, shows the state doing too much to punish. This dichotomy is central to modern governance. Where is the line? When does protective state action become punitive overreach? The Irish case sets a precedent for state accountability for inaction. The Indian case, depending on its outcome, could set a precedent for the reach of state accountability for online speech made by non-residents. Let's bring in some numbers to frame this discussion. Consider the scale of online activity and state responses. In India alone, according to digital rights watchdogs, there were over 1,500 cases registered under cyber laws related to online speech in the year 2024. Of these, an estimated 15% involved non-resident Indians or foreign nationals. The average time for resolution of such cases in lower courts can exceed 18 months. For someone like Dr. Patel, that's a potential year and a half in legal limbo, away from his career and family. On a global scale, a study by the Freedom House Network in 2025 rated only 22% of countries worldwide as having a free internet environment, a decline from 28% 5 years prior. The pressure on digital expression is increasing, and the tools of enforcement, like travel bans, are becoming more severe. So, what are the potential resolutions and wider implications? For Dr. Patel, his immediate future depends on the Indian legal process. He could seek anticipatory bail to avoid arrest while the case is heard. He could challenge the lookout circular in a higher court, arguing it's a disproportionate infringement on his liberty. Diplomatic channels between the UK and India may also be engaged, though governments are typically reluctant to interfere in another country's active legal cases. The British Foreign Office would likely provide consular assistance, but cannot override Indian law. The long-term implication, however, is for the millions of people who live transnational digital lives. This case tests the principle of digital dual citizenship, where you are physically in one country but your speech exists globally. It asks, can you be held legally accountable by a country you are merely visiting for online speech you made elsewhere? The precedent is worrying for journalists, academics, activists, and even ordinary citizens with family abroad. Furthermore, this story intersects with the business of big tech. Social media platforms like Meta, which owns Facebook, often find themselves caught in the middle. They are pressured by governments to remove content that violates local laws, while also facing criticism from human rights groups for complying with censorship requests. In 2024, Meta's transparency report showed it complied with approximately 65% of Indian government requests for user data and content restrictions. This puts the platforms in the role of de facto arbiters of global speech, often making decisions based on the legal pressure of the country with the most leverage. The individual user, like Dr. Patel, can become collateral damage in this tug of war between corporate platforms and sovereign states. In conclusion, the case of the UK doctor stuck in India is a microcosm of a macro problem. It's about the old concepts of borders and sovereignty crashing into the borderless reality of the internet. It's about whether the tools of state security are appropriate for policing public debate. And it's about the very real human cost when digital words have analog consequences. As President Macron pushes for global social media bans for the young, and as courts in Ireland penalize states for failing to protect, we are collectively grappling with a single, difficult question. In our interconnected world, what is the proper balance between protecting society and preserving the freedom of the individual? The answer will define not just the future of the internet, but the future of open societies themselves. For Kenya News Update Today, I'm your host. Thank you for watching. Subscribe to Kenya News Update Today.